good evening to everyone from Paris. I'm Frédéric Lecomte. As Sherwin said, power of the DPA and sanctions have been greatly reinforced by the new regulations. But those powers and sanctions are only effective if they can be activated. So the questions, in fact, goes to one thing: who can act? In fact, the GDPR gives a right of action to two categories of persons. The data subject, directly or indirectly, as we will see, and the DPA directly. It must be noted that those actions can be started against controller or processor or both, which is new because under the old regulations or the current regulations, because the GDPR is not in force yet, only the controller could be held liable for a breach of the regulation. Now the processor can also be held liable and can be, in fact, dragged to court or sanctions by a DPA. So let's start with the data subject. The data subject can act if he considers that the processing of his personal data violates the regulations, or if he has suffered a material or non-material damage as a result of the violations. When I say non-material damage, I know that this is maybe a word that doesn't mean actual things for some of you. I mean moral damage, intangible damage, or psychological damage. So the GDPR grants three different ways to act to the data subject, and it can use these actions cumulatively or alternatively. That is to say, one can be used without prejudice to the others. The first action that is granted to the data subject is a possibility to lodge a complaint with the DPA if he considers that the processing of its personal data violates the regulations or infringes rights. The complaint must be lodged with the DPA of the member states of his usual residence, of his place of work, or the place where the alleged infringements has taken place. The purpose of these actions is only to obtain from the DPA a corrective or a coercive measure against the controller or the processor. And such measures, corrective or coercive, are decided after an investigation that is carried out by the DPA. The second action is a judicial action and is available before the court if the data subject considers that his rights again have been infringed by a processing, or if he has suffered a material or non-material damage as a result of the processing. This action is brought before the civil court of the member state where the controller or the processor has an establishment. Alternatively, such proceedings may also be brought before the courts of the member state where the data subject has his usual residence, unless the controller or the processor is a public authority of a member state. The aim of this action is to obtain from the court a corrective actions or a compensation for the damage suffered. The third action that is granted to offered to the data subject is a kind of class actions, which is a type of action which is very new for most of the European countries. This action is quite complex to put in place because it must be started by a not-for-profit body, organizations or associations pursuant to a power that is given by data subjects in case their rights are infringed by a same company. The purpose of this action is to obtain enforcement of the regulation and to receive compensations, but only if the compensation is available in the relevant member states. For example, in France, this right is not available for the specific actions, and the aim of this action is only to obtain the injunction from the court, but not compensation. About the DPA itself, the DPA will start investigation and may decide sanctions against a processor or a controller on the basis of a data subject complaint, as we just saw. And it can also decide on its own initiative to start an investigation. These investigations will be started either randomly or upon actual suspicions of violations of the regulation. So let's start now. Let's see what are these powers that are granted to the DPA. Thank you. So in order to control the application of the GDPR and to enforce it, the DPA are endowed with a greater number of powers than the ones that they had under the current directive. This power can be exercised, again, against both controller and processor. This is very important to remind. Those powers are classified in two categories. You have investigative and corrective powers. Corrections and sanctions that Henrik will present you in a few minutes can only be decided and applied after a due and proper control and investigations have been carried out by the authorities. So the GDPR grants to DPA very broad and efficient power to investigate in company and state agencies. Among those powers, the DPA has the right to order the controller or the processor to provide any information that the DPA may require in order to perform its controlling duty. It can carry out data protection audit either online or on-site. It can review issued certifications. It can notify the controller or the processor of any alleged infringement of the GDPR. It can obtain access to all personal data and all information stored by the controller or the processor and that are necessary to perform, again, its controlling duty. And the more important one, it can obtain access to any premises of the controller and or processor, including access as required to data processing equipment and means. These are the principles that are, in fact, listed by the GDPR, but the GDPR leaves to each member state to organize the way the control and the investigations are carried out and to guarantee the right to a fair process. For instance, in France, the DPA controller have the right to conduct online control with an alias. On-site controls are also strictly regulated. The controller and the processor, they have the right to object to an on-site control. But in case the situation is critical enough or require an urgent DPA actions, the DPA can act pursuant to a warrant issued by a judge. The control process then applies pretty much like a police search, except that the police will not be necessarily involved in the first place. Let's speak about now about the cooperation between the DPA, because this is an important subject. We are in a union made of several countries, and the processing may have effect over different state member. So when the processing takes place in more than one member state, or if the breach may have impact in several member states, the DPA are required by the GDPR to coordinate their actions. So the companies, when they start operating in France, hello? Can I hear you? Yeah. Company must understand when they start operating in Europe, DPA do not act only locally, but the GDPR organizes a true system of cooperations between all the DPAs in order to ensure an harmonization of the application of the regulation. So each company having establishment in several member states, the DPA of the country of the main establishment is called the lead DPA. The of the member states, the other member states are the concerned DPA. Having said that, the rules are quite complex, but can be summarized like this, in fact. A concerned DPA cannot take actions without consulting the lead DPA of a company, and the lead DPA must consult the concerned DPA of any country where the lead DPA thinks the violation is likely to have an impact. The lead DPA must coordinate the investigation and consult the concerned DPA about the proposed sanctions to be applied. This mechanism, in fact, is supposed to maintain a consistent approach of the application and enforcement of the GDPR. This is known as the consistency mechanism. So when a control takes place, it is important to know how to react. So when control takes place on site, the processor or the controller have the right to be assisted. It is therefore very important to involve your DPO, if a DPO has been appointed, or to contact your local lawyer. In fact, because the GDPR leaves to each member state to define the rule and procedure necessary to enforce the regulations, control and enforcement rules may vary or may be substantially different from a place to another, and local competencies must be hired immediately if the situation cannot be managed internally. So the first very important elements to bear in mind is the cooperation. This means first that you must be able, as a company operating in Europe and having a control by a DPA, you must be able to demonstrate your level of compliance. And this demonstration is available through the principle of accountability, which is one of the pillars of the data management in the GDPR. Under this principle, the company is not only required to implement appropriate technical and organizational measures to ensure its data processing operations are privacy compliant, it is also required to be in position to demonstrate such compliance. So if you are able to demonstrate a good general level of privacy compliance within your organization, you will likely receive more lenient treatment from DPA in case of an infringement. Therefore, it's absolutely crucial to formalize and document your privacy compliance measures and to be able to show the compliance on an open book basis. It means also that you must bring all necessary explanations, so as much as good faith as possible, continue the cooperation during the overall process and not only during the on-site control, and show your desire to apply the regulation and the DPA request and recommendation as soon as possible. Cooperate does not mean that you cannot defend or not oppose without valid reasons. You can object to the communication of information if such information is classified or privileged pursuant to the law. In client attorney privilege concept work in most of the European countries for all communication between a lawyer and his clients that cannot be communicated to a third party, not even to a court. The same for medical files that are covered by the highest level of confidentiality that can be opposed to the DPAs. In case of an infringement, cooperate with the competent DPA is very important. You must make information available to DPAs, comply with their guidance and requests, attempt to mitigate any damage suffered by data subject, and even consider a proactive infringement notification to the DPA in certain cases.